Welcome, everyone. I am so thrilled you are joining us for this deep dive into our latest stack of source material.
It's going to be a really good one today.
It really is. So imagine, if you will, being held hostage in your own outhouse.
Oh, wow.
Right. But you are not cornered by a person with a weapon. You are cornered by your neighbor's vicious 200-pound boar.
That is terrifying.
It's the stuff of nightmares. You have a terrible choice to make. Do you stay trapped in that tiny wooden shack indefinitely, or do you make a desperate, terrifying sprint for your car?
Yeah, that is a tough spot.
If you make a run for it and that boar catches you and bites you, is it your fault for choosing to run? Or is your neighbor entirely to blame for the situation? Today, we are talking about the doctrine of strict liability for dangerous animals, the defense of contributory negligence, and the very real limits of what it means to assume a risk. Okay, let's unpack this.
That is exactly the perfect setup for what we are going to explore today. To really understand how courts handle these totally bizarre high-stakes neighbor disputes, we need a roadmap. First, we will establish the baseline doctrine of strict liability for abnormally dangerous domestic animals. Then, we will examine why the classic defense of contributory negligence is categorically rejected here. Finally, we will dissect the defense of voluntary assumption of risk and how a lack of reasonable alternatives just destroys voluntariness. And we are going to rigorously break down the court's reasoning element by element.
I really cannot wait to get into this because the stories in these cases are just wild. Let's start with that baseline doctrine. What rule applies when a domestic animal goes rogue?
The general rule comes from the Restatement of Torts, specifically sections 507 and 509. The rule establishes strict liability for abnormally dangerous domestic animals. And there are three elements. 1, the defendant possesses a domestic animal. 2, the defendant has reason to know, or should know, the animal has dangerous propensities abnormal to its class. And 3, the animal causes harm.
Okay, so it's not just owning the animal, it's the knowledge. But the text makes a real distinction between reason to know and should know.
Yes, the policy distinction is vital here. Reason to know means inferring a fact from information, like you see the dog snarling, so you infer it's dangerous. But should know implies a duty to ascertain the fact. It means you actually have a legal obligation to investigate.
You can't just close your eyes and claim ignorance.
Oh, exactly.
That makes sense. Let's apply this. Let's analyze Copley v. Wills. First, what are the legally dispositive facts?
In short, the case involves a plaintiff seeking damages after being injured by a vicious animal kept by the defendant. The catch is that the plaintiff was arguably careless in failing to discover the danger or take precautions.
And what was the core legal issue?
Is contributory negligence an applicable defense against an action for strict liability for keeping a vicious animal?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court relied on the Restatement, 2nd of Torts, Section 515, Comment B. The black-letter rule is, ordinary contributory negligence is not a defense to strict liability. The single element to evaluate is whether the plaintiff's conduct was merely a failure to exercise reasonable care to discover the animal or take precautions.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the nature of the plaintiff's negligence?
The sub-issue here is, did the plaintiff merely fail to discover the danger or take precautions? The sub-rule states that such failures are ordinary negligence, not an intentional assumption of risk. Applying the policy, the law places the full responsibility for preventing harm on the defendant who chooses to keep a dangerous animal. The conclusion is that the element defining ordinary negligence is met, meaning it is legally irrelevant as a defense.
And after analyzing all the elements, what was the court's final conclusion?
The court concluded that contributory negligence cannot bar recovery in a strict liability action for vicious animals.
Which brings us to a case that reads like a rural thriller. Let's analyze Marshall v. Ranne. First, what are the legally dispositive facts?
Paul Marshall raised about 200 hogs. His neighbor, John Ranne, had a boar that escaped and charged Marshall 10 to 12 times previously. It actually held him prisoner in his outhouse and attacked his wife.
Just completely terrorizing the farm.
Exactly. Marshall left a note on Ron's gate saying, "John, your boar has gone bad. We're going to have to get him out before he hurts someone." Later that day, Marshall walked 30 feet to his pickup to go to Dallas. The boar charged from behind and severely bit his hand. Marshall didn't shoot the hog because it wasn't neighborly, and he feared criminal charges. The jury awarded $4,146, but found Marshall contributory negligent for not shooting it or fixing his fence, and found he voluntarily assumed the risk.
And what was the core legal issue?
Is a plaintiff deprived of a voluntary and free choice in confronting a risk as a matter of law when the defendant's tortious conduct leaves the plaintiff with only a choice of evils?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The rule comes from Restatement, 2nd of Torts, Section 496E. The rule has two elements. First, the plaintiff must accept a risk of harm. Second, the acceptance must be voluntary. Acceptance is not voluntary if the defendant's tortious conduct leaves the plaintiff no reasonable alternative course of conduct in order to A, avert harm to himself or another, or B, exercise or protect a right or privilege of which the defendant has no right to deprive him.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, acceptance of the risk?
The sub-issue is, did Marshall knowingly expose himself to the boar? The sub-rule is that the plaintiff must have knowledge of the dangerous propensity. Looking at the facts, Marshall clearly knew the boar was vicious. He wrote the note, he had been trapped before, and testified he always looked out for it. So the conclusion is that element 1 is met. Marshall knew of and faced the risk.
Understood. Now what about the second element, voluntariness and reasonable alternatives?
The sub-issue is whether Marshall had a reasonable alternative that made his choice voluntary. The sub-rule states a choice is involuntary if forced between surrendering a legal right or facing danger. Ranne argued Marshall had alternatives: stay inside the house or shoot the boar.
Before we conclude, Marshall, let's analyze the precedent the court relied on. Harvey v. Seal. First, what are the legally dispositive facts?
A 9-year-old child played on a front porch her father held by lease, and she stepped in a hole left negligently unrepaired by the respondent.
And what was the core legal issue?
Did the child voluntarily expose herself to danger by deciding to play on the porch?
What rule of law did the court apply?
Yeah.
Please state the full black-letter rule and break it down into its testable elements.
A plaintiff's choice to encounter a risk is not voluntary if, first, the plaintiff is legally entitled to be on the premises, and second, the defendant adopts a take-it-or-leave-it attitude, forcing a choice between foregoing a legal right and encountering the risk.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, legal entitlement?
The sub-issue is, did the child have a right to be on the porch? The sub-rule states, a leasehold grants rights of use without the owner's further consent. The facts show her father leased the property. The conclusion is that element 1 is met.
Understood. Now what about the second element, forced choice foregoing a DWIC?
The sub-issue is, did the negligent failure to repair force an involuntary choice? The sub-rule dictates a defendant cannot discharge their duty by merely forcing a plaintiff to abandon their rights to avoid danger. Factually, the child had to choose between never playing on her own porch or risking the hole. The conclusion is element 2 is met. The choice was not voluntary.
And after analyzing all the elements, what was the court's final conclusion?
The respondent owed a duty, and the child did not voluntarily assume the risk.
Let's bring this back to Marshall v. Ranne. We were discussing whether staying inside or shooting the boar were reasonable alternatives. How did the court resolve that?
The court analyzed those exact alternatives. Staying inside meant Marshall would surrender his legal right to proceed over his own property to his car to travel to Dallas. Shooting the boar was not a reasonable alternative because it would subject Marshall to charges under 2 criminal statutes. So the conclusion for the second element of Marshall is that it is not met. Marshall had no free choice. He had only a choice of evils imposed by Ranne.
And after analyzing all the elements, what was the court's final conclusion?
Because Marshall was forced to choose between his legal right to access his property and facing the boar, his assumption of the risk was involuntary. The jury's finding of contributory negligence was irrelevant to strict liability. The Supreme Court of Texas reversed the lower courts and rendered judgment that Marshall recover the $4,146 in damages.
Here's where it gets really interesting. I want to test this difficult rule of voluntary assumption for you with a pretty wild hypothetical.
I am ready.
Imagine you're in your kitchen and your neighbor's illegally hoarded, rabies-infected emotional baboon breaks in and blocks your front door.
That is quite the image.
Your only other exit is jumping out a third-story window into a dumpster completely filled with rusted needles and medical waste. If you choose to sprint past the baboon and it bites you, did you voluntarily assume that risk?
What's fascinating here is exactly how strictly the law applies. Applying Restatement Section 496E, jumping into medical waste is definitely not a reasonable alternative.
Obviously not.
Right. And nor is just starving to death inside your kitchen, which deprives you of your right to move freely. Therefore, running past the baboon is a choice of evils wrongfully imposed by the neighbor. You did not voluntarily assume the risk. The law protects your freedom of movement over the neighbor's negligence.
So what does this all mean for the listener if they have to issue spot this on an exam?
You need a structured checklist. Here is the step-by-step diagnostic. Step 1. Identify the animal and the defendant's knowledge. Is it a domestic animal? If so, look for facts showing the owner had reason to know, inferred from facts, or should know, meaning a duty to investigate, of its abnormally dangerous propensities under the restatement.
Got it.
Step 2. Establish strict liability. Once the animal's vicious nature and the owner's knowledge are established, strict liability applies if the animal causes harm. Step 3. Cross out contributory negligence. If the exam fact pattern shows the plaintiff was merely perilous, like failing to build a fence or discover the animal, immediately cross it off as a defense. It does not apply to strict liability, just like we saw in Copley v. Wills.
It's totally irrelevant.
Exactly. And finally, step 4. Scrutinize assumption of risk for voluntariness. If the plaintiff knew of the risk, ask, did they have a free choice? Look for the choice of evils. If the fact pattern forces the plaintiff to surrender a property, right, like in Harvey v. Seal or Marshall v. Ranne, or forces them to commit a crime to avoid the danger, the choice is involuntary as a matter of law. The defense fails.
That is an incredibly helpful framework for breaking these scenarios down.
We've established that you don't have to surrender your property rights to avoid a neighbor's vicious animal. But this raises an important question for you to ponder. In an increasingly bent society, where does your right to quiet enjoyment of your property end and your neighbor's strict liability begin? If Marshall had simply shot the boar and faced the criminal charges, could he have sued Ranne for the legal fees incurred from the criminal defense, seeing as Ranne's tortious conduct forced that choice of evils?
That is an incredible question to leave off on. Thank you to everyone for joining us for this deep dive into the source material. See you next time.